Let's look at a mistake a lot of people make, and that is they get a will. And you're going, well, yeah, I want a will. By the way, my name's Lee Phillips. I'm an attorney, and I've done hundreds and hundreds and hundreds of wills and trusts, and I've worked with a lot of people. In fact, in live audiences, I've actually trained over 500,000 people on this estate planning stuff that we're going to talk about. Here's the mistake. The attorney brings you in and he locks you in. You get married to your lawyer. You're on the hook. The lawyer says, you don't want a trust. You just want a will. And there actually is an argument in the legal profession as to whether you should get the living revocable trust or just the will. And there are arguments on both sides of it. I'm going to come down on the side of the trust because the trust will allow you to avoid probate if you do it right. And probate, they'll say, oh, probate's easy. We have new laws. And actually that's true. We do have new laws in most states. We have the Uniform Probate Code. The problem is at the point where a family member dies, the family is particularly vulnerable. And would you believe that there are a few attorneys that would take advantage of that vulnerability? I know that's hard for you to believe, but it does happen sometimes. The attorney brings you in, he does just the will. Well, okay, do you just need a will? Let's look at it for 2 seconds. If you have property, real estate, bank accounts, stocks, bonds, all of these sorts of things, CDs down at the bank, and you die, then you are going to go through probate, or your family's going to go through probate with those assets. Now, don't do the joint tenancy stuff. That's one of the other mistakes that people make, and that's on one of the other videos. You learn about that one. But you want to avoid probate. Well, okay. Attorney says not a big deal. Just do the will. If you've got these assets, frankly, I think you need to look at a living revocable trust. Now, there are a lot of states that have minimums. $60,000, $80,000 minimum for probate. If we have under $60,000, then the whole probate process, so you still go through probate process, but it can all be done by signatures and affidavits. We don't have to go to court. We don't have to publish. We don't have to do the big probate. But you still have a probate process. What probate is it's the court's authority for somebody to sign your name after you die. So to get into the bank account, get into the safe deposit box, I've got to have a signature. You're not there to sign. Who signs? The bank isn't going to let your son in, even if he has a will. It says right here, I'm the owner of the safe deposit box after mom and dad died. See, right here in the will. The bank isn't going to let him in. 1, they don't know that it's the real will. 2, they don't know you didn't make out 6 wills. They don't know all of this. So the kid's got to go to court. He's got to prove it's the real will. He's got to prove you didn't owe anybody money. Because if you owed people money, they get the first crack at all the assets in the estate. So we go to court, we prove all of these things, and then the court issues what's called a letters testamentary. And I talk about that in the book. You'll figure that one out easy. The whole process of probate is explained in detail. But he goes to court, he gets the court order, then he can go in, he can get the safe deposit box. Well, you want to avoid all of that stuff. And yeah, I can do it, but it is expensive, even if I'm trying not to run my clock. It is relatively expensive. There's time. There's a lot of time involved in it. There's a lot of money then. There's a lot of frustration. In fact, it happened in my neighborhood, not 4 or 5 houses away from me. Dad dies. The brothers and sisters all get together. And this probate process has run out for a year or more now. One of the brothers becomes very frustrating. And he says, okay, I've got to have a meeting with all my brothers. So all the brothers come together. And they meet one night in home. It was a cabin, actually. The brother was so frustrated with this process. He felt like his brothers were cheating him. I mean, the first 3 or 4 weeks after somebody dies, everybody's happy. But the longer it goes on, the more the neighbor down the street says, you know, my brother screwed me when Dad dies, or this happened or that happened. This brother became so frustrated when he brought the other brothers in for the meeting, he brought a gun with him. He killed his other 3 brothers. And then actually the cops ended up killing him a day or so later in a high-speed chase. That's what probate does to some families. Unless you've been through it, you don't understand the cost. If you have just a will, you're always going to have probate if there's property where you have to sign a signature on. So you can avoid the probate, you just go right out and around it, it's no big deal. But the lawyers love probate. They actually create what are called will files, and they write wills. They'll write wills all their life, and they know that in 90% of the cases, the family's going to come back to them as soon as the family member dies. So you always go back to the lawyer who wrote the will. In fact, I had a case this week where the lady called me. She was going in for a critical operation, and she says, Lee, I've got my trust, and you looked at my trust a number of years ago, and you said that it was okay, that I didn't have to redo it or anything. She's a single lady. It's no big deal. I'm not going to make her pay for another one when the trust she's got is reasonable. However, there is a provision in the trust that says, when I die, immediately call Mr. Lawyer so-and-so. And she says, I don't want family to go to this lawyer. I don't even like the guy anymore. Does the family have to go? She was under the impression that because it said in the trust, immediately upon death, call so-and-so, that the family had to do that. And the answer is no, you don't have to do that. But the lawyer's working you in. He's building the will file. In this case, it was a trust, but he's still bringing you back in. And so you get stuck. The lawyer keeps the will. That's another way that he locks you into him. No, you get the will. You get the original will. You got to have the original will if you're going to change it. The lawyer doesn't want to give you the original will, because then you can go to any attorney down the street. It's very uncomfortable if you have to come back to the lawyer and say, well, give me the original will. I'm going to redo it with Joe down the street. So they keep the will. There was actually a big law firm in Denver a number of years ago, and they had the big vaults with all of the wills and stuff in it, and they started to clean out the vault, and they figured they had literally hundreds of wills where the man or the woman had died. Family had never come back to get the will, and they started to look into it. Family didn't know the will was there. The lawyer had the will. Family didn't know the lawyer had the will, and these families had gone through all of the probate process, everything with Dad's estate, intestate. That means you die without a will. They'd assume Dad had never done the will. So don't let the lawyers lock you in. You're the trustee. You're the guy in control. You decide what's going to happen. You never abdicate that to the lawyer. Never let the lawyer set himself or herself up as trustee or as executor or executrix. We call them personal representative now. That's the enlightened way to do it. But never let the lawyer put themselves in these positions, because then you're stuck big time. In my book, I go through and I show you exactly what you need to do, what part the lawyer should play, what part you can play. And you have to take an active part in this. The mistake is, I don't know anything about it. I'll just turn it over to the lawyer. He's going to take good care of me. Yeah, right. If mom and dad are getting older and they haven't done this, you need to get them to do it, and you can't go in and talk to them. Get the book and give it to them so that they understand what can be done, what can't be done. Once they understand what they can do, what they can't do, and why they're supposed to do it, it's easy, they'll do it. So look at one of the other 6 videos if you like. Get the book. We go through all of this in detail. I tell lots of fun little cute stories that make my point on each of these issues. This is Lee Phillips. I'm an attorney. I'm giving you mistakes that people make in estate planning.